alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask me any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters ranging from criminal law matters, family law matters, whatever your legal questions are. Please do pick up the phone and give us a ring, and inshallah we can have a discussion with you regarding your concerns, your queries, etc. A couple of minor points before we get going. On the show, occasionally we get quite complex questions. Occasionally I need to look at your documents before I can advise you properly. Now, if it transpires that your matter is quite complex, or I need to look at documents before I can advise you properly, then I will ask you to leave your number with the control room, and then I will have that more thorough discussion off air with you once I've taken detailed information from you, once I've had the opportunity to look at the documents that you want me to look at. But the vast majority of questions that we get live on air, whether it's by way of a phone call or whether it's by way of a message on that mobile number, which is there at the bottom of the screen, I'm able to cover all of those live on air. So 2 ways to get in touch: landline number for a live call through to me here and speak to me live on air, mobile number for any messages you want to send in with your questions. Now, messages that are sent in on legal questions, we get numerous questions coming in during the day. Even before we've come on the show today, we've had a number of questions coming in. So I'll start going through your questions. Continue, please, to send your questions in. So now let's look at one of the first questions that's come in. I was just about to turn to the questions that have been coming in, but we have a caller who's been waiting. So let's go to our first caller of the day. Hello, assalamu alaikum.
Wa alaikum salam, brother. How are you?
Alhamdulillah, good. How are you, brother? You okay?
I'm okay, mate. Thank you. Right, I got a few questions to ask you regarding to visit visa.
No problem.
Just the first one is, right, how many month bank statement need from for the sponsor, someone coming into the UK for a visa?
Okay.
That's included the sponsor as well. Sorry, so one applicant and a sponsor, the both of them.
Okay, so I think in terms of the sponsor in the UK, I say minimum of 3 months. 3 months is generally sufficient. You don't need to put 6 months of bank statements in for the sponsor in the UK. 3 months is fine.
Right, so the first should be the date basically you're applying from the backward from the date of you make an application.
Yeah, I mean, ideally you don't want to put in old bank statements. You want stuff which is recent as well. So if you were doing it now, you'd want maybe July, August, September. So that's the way you...
Right. What about the applicant?
You see, the applicant is different. My view is, for the applicant, the longer you can put in, the better. Absolute minimum would be 6 months for the applicant.
6 months.
Absolute minimum. I always say to their clients, try and put a bit more in. If you can get something between 6 months to 9 months, because what we're trying to do is show them the applicant's financial circumstances. And, the shorter the period, the more likely it is that they believe that this might have been exaggerated, the financial circumstances towards the end. But if you're able to show documents which span, for example, 1 year, it's more difficult for them then to say, oh, it's exaggerated, because you can see the bank statements for a year, you can see the entries and the money leaving the account. So it's more difficult for them to think, you know what, you've exaggerated the circumstances towards the end. My personal view is the longer the better.
Yeah, that's fine. Can I ask you something? It's a bit, obviously, a tricky one as well. How much money, I mean, I'm basically a sponsor my dad, right? So how much money he should have in his bank account, right? I mean, is to make application a bit, obviously, more stronger, right? So
I think, for dad who wants to come here, I think the starting point should be not so much what he needs in his bank account, but what evidence of income do we have? What level of income do we have? So that's normally a better thing to look at. So if I give you an example, if he has, let's say, £600 a month coming in, and we can demonstrate it over a long period of time, and then Consistent with that, as an example, would be somebody who's got, let's say, £3,000 or £4,000 in savings. So that paints a picture where it all looks consistent. My only concern is, let's say we say dad has £600 a month coming in, but he's got savings of £20,000. It doesn't quite fit in that well. So it's the overall picture has to look right. Concentrate more on income that's coming in. Can we show that they are financially stable themselves by way of income coming in? Now, the second point is the point you're making about savings. If you've got, £3,000, £4,000 worth of savings, I think that's more than sufficient. But the key thing is demonstrating we have enough money coming in. He's got enough money coming in to look after his family, his financial needs going, from month to month. I think
Right. That's what they look at, right? Can I ask you one more thing? That you just see when you're making a basically application, any entry application, as fast as we make an application for someone for a person as well. Like, I mean, if I make an application online, and just for the system asks for upload the documents, just upload the documents, right? Make an appointment online and here as well, and then send all details obviously to Pakistan, right? And they could obviously do their biometric and submit their passport. Is that the way the work? Visitor visa application submitted as well as as submitted any entry clearance application. It's the same procedure basically, like.
What you've said is bang on right. The procedure is always the same, whether it's a spouse application, somebody coming on a work permit, or somebody coming on a visitor visa. Obviously, the form is different, but in terms of the process, online payment, online form completed, paid for, move to the VFS website and book an appointment, upload the documents there, inform the person who's abroad of the appointment, and they take the appointment printout, the document checklist, and their passport. And you've already submitted the supporting documents. So process is identical to the
exact same.
Absolutely identical. Application paid for, appointment booked, documents uploaded. In Pakistan, they take the appointment letter document checklist with their passport. You've already uploaded your documents.
Right, okay. Right, just before you go and ask someone, if they grant a visa, right? So what basically happened? How did it work with this one? Like, for example, if they grant the 1st of January 2023, so the visa basically is date stop from the 1st of January till end of the June. If they grant for 6 months, that's where the visa work, or they give us some sorts of flexibility time period. You could travel from certain days to the certain time. I mean, if they grant for 6 months.
Yeah. So the visit visa will be granted for 6 months. So normally what happens is, let's say you just submit a standard application and you don't say anything about when you want it to start. So, and it's just processed, you submit it in October, you get a December, 2 months later in December 15th. So it will be from the 15th of December to the 15th of June, I think. That's when the 6 months expire. So that's what we do. Now, what you can actually do is, when you do the visitor application, they ask you when you want the visitor visa to start. So you can pick a date up to 3 months in advance if you want.
Right.
So let's say you're doing it in October and you don't want it to start now because it's winter. So you don't want the application granted now. One option would be to say you want it to start on the 15th of January.
Right.
But the problem is, even if it starts on the 15th of January, it will then still only be for 6 months. And it's open to you to travel anytime during that 6 month period. Now, I think the problem now is because it's winter time, people don't want to do these visitor applications at the moment, because the visit visa application, if it's granted, it's going to be December, January, and you don't get much of the summer period. So sometimes it's better to make the application around December, get the decision in February, and then it gets you March, April, May, June, July, August. You get more of the summer months, better weather if they're coming over here.
Right, no worries. That's fine. Thank you very much for your help, right? Thank you very much.
No problem. Thank you very much for your call.
Thank you.
Thank you. Interesting call about visitors. And what we tend to find in practice is as we get towards winter, the number of queries regarding visit visas does actually go down, because it's not the ideal time for a lot of people to be sponsoring family members to come to the United Kingdom. As we go into the new year, February, March, April, you see slightly more queries coming in terms of visit visas. Right. As always, to get in touch on the phone, to speak to me directly on the phone, please ring on the landline number. And as always, please do continue to send your messages in on that mobile number, which is also there. Let's look at the next question that's come in on WhatsApp on that mobile number. So the question is as follows. Assalamu alaikum. My mother-in-law is poorly, 65 years old, and lives in Pakistan on her own. 2 sons, both in the United Kingdom. Can we apply to bring mother-in-law over to the United Kingdom to look after her, and for her to settle in the United Kingdom? Now, the problem is, and I will deal with this in greater detail because we have a lot of questions on this coming in. The starting point is, realistically, if mother-in-law is going to be able to get a visa, it's going to be a visitor visa to come to the United Kingdom to visit you. When you mention mother-in-law wanting to come to the United Kingdom to settle, to be cared for in the United Kingdom, that's quite difficult. That takes us into a completely different immigration rule, which is extremely difficult to satisfy. So generally speaking, elderly people who want to come, to settle with their children in the United Kingdom, it's not easy to bring parents, grandparents to the United Kingdom to settle. Normally, it'll be easier to bring them to the UK as a visitor, but to apply on the basis that they want to come and settle on a permanent basis is extremely difficult. And we are taking a short break. After we come back from our break, I will take you through what they look at when you apply for permanent residence for an elderly person who's abroad. It is quite difficult. We'll be back, inshallah, in the next couple of minutes. See you then. Assalamu alaikum. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, a very popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So landline number for live calls. We always like to speak to you and try and help you the best way we can. So landline number for the live calls and the mobile number for messages. And mashallah, we get loads of messages coming in on a daily basis. Now, just before the break, we were touching upon the issue about sponsoring an elderly person, maybe parents, maybe it's the in-laws, to the United Kingdom to come and settle with you, to settle with children in the United Kingdom. And I was explaining just before the break that that is quite difficult to do. My advice normally is, in this situation, what you should do is, if you can make a strong visitor application to sponsor your relatives, your elderly relatives, to come to the United Kingdom, that's always better. So in order to make a strong application, normally, unfortunately, the Home Office relies or focuses on the applicant who's abroad, their financial circumstances. So how can you make that quite strong? So make a strong visitor application, and once they come to the United Kingdom once, maybe they go back, they apply for another visitor visa and they come back again, and build up your immigration history so that later on, instead of applying for visitor visas for 6 months, you apply for a much longer period of time. So you apply for a 5-year visitor visa, you build it up to a 10-year visitor visa. But on each occasion, when you come to the United Kingdom, obviously you should only be staying for a few months and then going back. But what this approach does is that it means that you're able to build up your immigration history, and the Home Office has trust and confidence in you, so they're more likely to give you a longer term visitor visa. So you can come and go. There's a lot of flexibility there. Any occasions that you need to come for, anybody who within the family needs help and they need you to be here, maybe somebody's giving birth, etc., you're able to do that with greater flexibility. Now, the reason I say you should do that is that a visitor application is more likely to be successful. If you try an application for elderly relatives to come to the United Kingdom, to settle in the United Kingdom, most of these applications are refused. So understandable that you want your elderly relatives to come and stay with you here in the United Kingdom, but most of these applications are refused if you apply for them to come on a permanent basis. Now, the reason for that is this, that in order to qualify for a visa which leads to settlement, you have to demonstrate that your relatives are unwell. They need personal care. And that may be possible to demonstrate. So somebody may well be unwell, they may be bedbound, etc. So it may well be possible to demonstrate that they need personal care. The problem is this, that not only that, you also have to demonstrate that that level of care is not available in the applicant's home country. So nursing care, care home care is not available. And that's more difficult to do. What tends to happen with these applications is that the application is made, the Home Office generally will turn around and say, okay, we accept the person's related to you, we accept the person's unwell, we accept the person needs personal care. However, what we don't accept is that care is not available, professional care is not available in their home country. And that's normally fatal for the application. Now, the problem is then this, that once the application for your elderly relative to come to the United Kingdom and settle here is refused, later on, when you apply for a visitor visa, the Home Office, the immigration officer, will look at the previous application and say, you know what, you want to now go to the United Kingdom as a visitor. However, 3 months ago, 6 months ago, you were applying to come to the United Kingdom to settle in the United Kingdom on a permanent basis. So, we don't accept that at this stage, you are simply going to the United Kingdom as a visitor. Because 3 months ago, 6 months ago, your intention was to settle in the United Kingdom. Now, that will cause immense problem with your now current visitor application, and it's likely to result in that visitor application being refused. So that's why it's important to do it the way I would suggest, which is to get a strong visitor application in first. Concentrate on that. Now, once your relative is in the United Kingdom, and as I said, try and build up your good immigration history, they'll be able to come and go as they want. If many years down the line, if they are in the UK, if they fall ill, if they can't go back to their home country because nobody's there to look after them, then maybe at that stage you should take legal advice as to whether it's possible to apply for them to stay here permanently at that stage. So that's normally the better way to do it. But thank you very much for that question. Now, we've had a number of questions coming in. Let me look at the next question that's come in. The question relates to a work permit question. We get a lot of work permit questions now in practice as well. And our viewer asks, Assalamu alaikum. I own a care business. I've been approached by a potential applicant who is currently in the UK on a skilled worker visa and wants to transfer to my business. Is that possible? Okay. Now, in practice, you do get a lot of questions on skilled worker visas. So it's the work permit visa, which is now known as the skilled worker visa, similar kind of concept to before. And what our viewer is asking here is that they have a care home business, or a care business, I should say, and they've been approached by somebody who's already here in the United Kingdom with a skilled worker visa, whether they can switch employment, change from their current employer with whom they are sponsored. Can they leave that and become employed in the new business? And what's the process for doing that? Now, the starting point is this: yes, it is possible. There's no problem. Somebody who is in the United Kingdom with a skilled worker visa doesn't have to stay in employment with the same employer. They can change employer. So there's no restriction on changing employers. Now, it may well be that you've come to the United Kingdom, you've got a 3-year, 5-year visa with a particular employer. As I said, it's absolutely acceptable if you want to change employers. The only slight difficulty is when you change employer and you want to go to another employer, you will need to go to an employer who is also an employer with a sponsor license. So you've been sponsored by a business which has a sponsor license. They've sponsored you. If you want to move employer, you can't just go to any employer. It has to be an employer which has a sponsor license. And if you go to an employer that has a sponsor license, potentially, yes, they are able to sponsor you to work for you, and potentially, if you have a license, if you sponsor them, they are able to switch their visa from that employer to you. So in relation to, specifically in relation to your question, you're a care business, you've got a license, yes. If you have a vacancy, the salary is correct, and you request from the Home Office for a certificate of sponsorship because you've got a vacancy that you want to fill, you've identified a person. If you're granted that certificate of sponsorship, then yes, you can assign it to this new employee. The new employee can then apply to come and work for you. So absolutely possible. There's no problem at all with that. And obviously the old employer would then inform the Home Office that your employment with them has come to an end. That doesn't have any adverse effect on your employment. You now have new employment. That's absolutely fine. There's no problem with that. And it's sponsored employment. And the point I should make here is that obviously you will be looking at applying for indefinite leave in the United Kingdom, and your previous employment, your current employment under Tier 2 or under the skilled worker route, that can all be combined together. Once you've done a total of 5 years in the United Kingdom, you are eligible to apply for indefinite leave to remain. So it's not the case that you've changed employers, now you start from zero again and you build up another 5 years. That's not the case. You can add your previous leave as a Tier 2 skilled worker visa holder. You can combine it with the new employment, complete your 5 years, and then qualify for indefinite leave to remain as well on that basis. So absolutely possible in answer to your question. One minor point I should mention before we move on: there are costs implications of this. The person who's here might have paid considerable fees to get the visa. When you switch to another employer, you have to pay the fees again. So the immigration skills charge, the application fee for the visa, the NHS contribution, etc., all that has to be paid again. So it does end up being quite costly. So it's not, unfortunately, it's not that straightforward. So in answer to your question, it's possible. There is a process we need to follow, and there are costs implications of going down this route. But I mean, luckily, the way the scheme is set up, nobody's stuck with an employer. Certainly, if they're not happy there, the potential is there to move on and then continue in employment with the new employer. Now, skilled worker visas, sponsorship licenses are very popular topics at the moment. Taking a short break. We'll be back in the next couple of minutes. See you then. Assalamu alaikum. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, a very popular way of getting in touch is to send us a message on that mobile number which also appears at the bottom of the screen. So the landline number to speak to me live on air and the mobile number is to send us a message in. Now, as always, we've had a number of questions coming in. So let's go to the next question that's come in. Immigration law is always a popular topic. And the next question relates to immigration law and but more particularly, it relates to nationality law. Now, quite a general question on nationality law. Our viewer says, Assalamu alaikum. Would you be able to explain in general terms how I can qualify for British nationality? How many years residence do I need in the United Kingdom to qualify, and what are the other main requirements? Okay, quite a general question on nationality law, always a popular topic. Now, there are different rules relating to nationality. For adults, the rules are different. For children, the rules are different. And here the question appears to be about an adult applying for nationality. Now, I don't have specifics in terms of what this person's circumstances are, so I can only go through, give a general idea about what the requirements are likely to be when you apply for nationality. Now, for example, normally you would need indefinite leave to remain in the United Kingdom. That's normally one of the first things that you look for. If you haven't got indefinite leave to remain, generally speaking, you can't apply for British nationality. So have you got indefinite leave to remain? You then look at how long have you lived in the United Kingdom. Generally, you need to have lived in the United Kingdom for 5 years. If you're married to a British citizen with 3 years residence, you can qualify for nationality as well. Now, at the moment, spouse applications or spouse rules are such that you only qualify for indefinite leave to remain after you've been married for 5 years. So spouses who are in the UK, who've got indefinite leave to remain, would have obviously lived in the UK for 5 years already. So have you got indefinite leave to remain? Have you lived in the United Kingdom, generally speaking, for 5 years? Now, just on that point, if you're married to a British citizen, it doesn't matter how long ago you got your indefinite leave to remain. Even if you got it a couple of days ago, a couple of weeks ago, it's fine. You can still apply. If you're married to a non-British person, then you will need to wait 1 year after you get your indefinite leave to remain before you apply for nationality. So we've got, have you got indefinite leave to remain? How long have you lived in the United Kingdom? So they're normally the things that you look at initially. The other thing in practice that you look at is absences. How much time have you spent outside the United Kingdom? There are rules about the permitted level of absence in the year before submitting the application, and there are rules relating to absences over the 5-year period before you apply for indefinite leave to, before you apply for nationality. Generally speaking, in relation to absences in the last year, you can be absent up to 100 days in the last year. If your absences exceed 100 days, it is possible for your application to be refused based on your absences. And the Home Office also looks at your level of absences over a longer period of time, over a period of 5 years. How much time have you spent abroad? Generally speaking, if you average it out, 3 months per year in terms of absences is permitted over the last 5 years. So potentially something in the region of about 15 months. Now, if you exceed that, but you're able to demonstrate that you've actually been in the UK for much longer than 5 years, you might have been here 7, 8 years. So if you can demonstrate a longer period of residence, if you can demonstrate your strong links with the United Kingdom, such as your family's here, your assets are here, your business is here, etc., then it is possible that even if your level of absence is quite high in the 5 years prior to applying, your application could still be approved if other requirements are met. You've been here a long time, and it just so happens that in the last 5 years your level of absence is quite high, but you've actually been here much longer, and you've really, as a family, as your assets, etc., you've really established yourself here, then you could get away with a longer period of absence as well. So you always look for, have you got indefinite leave to remain? Have you got enough residence in the UK? What's your level of absence? Is it within the permitted rules? Now, one of the other things that you look at, and this sometimes does cause a problem, is whether you have any criminal convictions or not. If you have criminal convictions, then it could be problematic. Now, normally in practice, what you come across is people who've got minor motoring convictions. So they might have points for speeding, points for going through red lights, etc. Now, the starting point with that is you do need to declare those convictions, because if you don't, the application could be refused on the basis that you've not been honest. So you do need to declare those convictions. However, if they are minor motoring matters which have been dealt outside court, then the likelihood is that they will be ignored. Certainly, the guidance seems to suggest that where you've got points, matter dealt with outside court, 3 points, 6 points, etc., that will generally speaking be ignored. The problem with motoring matters is when the matter is dealt with in court, because it's too serious to be dealt with outside court. So, for example, dangerous driving, reckless driving, etc., where it's not going to be dealt with by way of fixed penalty. It's a matter that ends up going to court. Now, if it ends up going to court and you get a fine in court, then that won't be ignored by the Home Office. It will result in you not being able to apply for nationality for a certain period of time, depending on the sentence that's been issued. It could be you have to wait 2 or 3 years. It could be longer, depending on if it's on a more serious criminal matter where you receive a custodial sentence. So it just depends on what the outcome is as to whether the criminal conviction is going to affect your nationality application or not. So in a nutshell, I know you've asked quite a general question. There are a number of requirements that do need to be fulfilled. Let's go to our next caller. Hello, Assalamu alaikum. Hello, Assalamu alaikum.
Walaikum assalam.
Thank you for calling.
Hello.
Hello, Assalamu alaikum. जी, you're live on air.
मुझे आवाज नहीं आपकी ज्यादा
जी, आप लाइव है. अगर आप टेलीविजन के पास है ना, तो वहां से थोड़ा सा अगर आप जी, आवाज आ रही है.
जी जी, आपको आ रही है मेरी आवाज?
जी, मैं सुन सकता हूँ. जी, आपकी आवाज आ रही है. जी
जी, मुझे ना क्वेश्चन ये पूछना था कि मेरे नीस है, तो उसका भाई इधर होता है इंग्लैंड में
जी.
तो उसके पास ब्रिटिश पासपोर्ट है और वो सेटल है यहाँ पे. तो उसने अपनी बहन को स्पॉन्सर किया था, लेकिन बहन जो है ना वो सिंगल है, शादी नहीं हुई अभी ना. तो उसने सिर्फ ना विजिट वीज़े के लिए अप्लाई 2 बार किया है, लेकिन वो रिफ्यूज़ हो गया, नहीं लगा कि क्योंकि वो सिंगल है और इसलिए. तो कोई है ये सिस्टम कि अगर यहाँ पे आप गारंटी रखवाते हैं 10,000 पाउंड कि वो वापस चले जाएंगे, تو وہ اس گارنٹی پہ ویزا لگ جائے.
جی وہ گارنٹی والی سسٹم تو نہیں ہے یہاں. کافی سال پہلے یو کے گورنمنٹ نے کچھ بات کی تھی گارنٹی کے بارے میں. بانڈ وہ کہتے تھے کہ اتنے پیسے ڈالیں گے تو ویزا دیں گے, مگر پھر وہ کبھی بھی لا اس کو نہیں بنایا اس نے. سو گارنٹی کی سسٹم, بانڈ کی سسٹم نہیں ہے امیگریشن رولز میں. سو آپ کو کیا کرنا پڑتا ہے جو نارمل ویزا کے لیے اپلائی کرتے ہیں نا, کہ وہاں سے اس کی انکم بتاتے ہیں, اس کی فیملی
اچھا,
سرکمسٹانسز.
لیکن وہ اگین کر سکتے ہیں, مطلب یہ کہ وہ کر سکتے ہیں دوبارہ اپلائی کر لیں,
جی
دوبارہ وزٹ ویزا اپلائی کر
جی
لیں,
کر سکتے ہیں.
اور اپیل ہو سکتی ہے اس کی.
اس میں اپیل نہیں ہوتی ہے, مگر اس میں چیلنج تو کر سکتے ہیں اس کو. اس میں ایک سسٹم آتی ہے چیلنج کرنے کے لیے, اس کو جوڈیشل ریویو کہتے ہیں. تو اگر اس نے کوئی رانگ ڈیسیجن لیا ہے تو آپ جوڈیشل ریویو میں جا سکتے ہیں. جی آپ ہے نا, آئی تھنک ٹی وی کے پاس ہے نا, اگر ٹی وی سے تھوڑا سا آپ ٹی وی کو تھوڑا سا والیوم ڈاؤن کر لینا تو آواز آئے گا. جی تو میں نے یہ بتایا نا کہ اپیل نہیں کر سکتے, مگر جوڈیشل ریویو ہوتا ہے اس کا. اور جوڈیشل ریویو کے بارے میں بیسٹ ہے نا, آپ اگر ریفیوزل آیا نا تو آپ یو کے کا کوئی امیگریشن سلسٹر ہے تو آپ اس سے بات کریں گے تو وہ آپ کو ایڈوائز کر سکے گا اس کے بارے میں.
ٹھیک ہے.
ٹھیک ہے نا. مگر
اور ایک اور کویسچن میں نے پوچھنا تھا,
جی
وہ یہ تھا کہ ورک پرمٹ کے بارے میں,
جی
کہ اگر جو لائسنس لیتے ہیں ورک پرمٹ کا,
جی
تو وہ ان کی کتنی انکم ہونی چاہیے جو لائسنس لیتے ہیں ورک پرمٹ کے لیے, جو
بزنس کی
جو کوئی کمپنی ہو یا اس طرح ہو,
ہاں
تو وہ کتنی ان کی آمدنی ہونی چاہیے انکم, کہ وہ لائسنس اپلائی کر سکتے ہیں.
جی انکم کی کوئی لمٹ نہیں ہے اس میں. وہ صرف دیکھتے ہیں کہ کتنے بندے کام کر رہے ہیں وہاں, وہ زیادہ دیکھتے ہیں, مگر انکم نہیں دیکھتے, ٹرن اوور نہیں دیکھتے, پروفٹ بھی نہیں دیکھتے. وہ
تو یہ نہیں ہوتا کہ اگر وہ دیکھتے ہیں کہ یہ سال کا اتنا ٹیکس پے کر رہے ہیں, اس کی کوئی لمٹ نہیں ہے انکم کی؟
نہیں, وہ انکم نہیں دیکھتے اس میں, کیونکہ کوئی نیا بزنس ہے نا, تو اس کے پاس تو کوئی ٹیکس بیکس نہیں ہوتا ہے نا, تو وہ نہیں دیکھتے. وہ دیکھنا چاہتے ہیں کہ بزنس کیا کر رہے ہیں, کتنے لوگ کام کر رہے ہیں, اس پہ زیادہ فوکس ہے اس کا.
اچھا, تو اس میں آپ جیسے پلمبر, الیکٹریشین
جی کر
اور
سکتے ہیں,
شیف اور اس طرح کی بھی بلا سکتے ہیں بندے؟
بلا سکتے ہیں. وہ اسکلڈ ٹریڈ ہے نا, وہ اسکلڈ بندے ہیں, اس کو بلا سکتے ہیں. الیکٹریشین,
ٹھیک ہے,
بلڈر بلا سکتے ہیں اس کو.
ٹھیک ہے.
ٹھیک ہے.
تو اور میں نے پوچھنا تھا کہ اگر جیسے یہ اسٹوڈنٹ ویزے کے لیے,
جی
تو اگر ایک
جی
فیملی آتی ہے, جیسے
ابھی ہم تھوڑے سے وہ بریک لینے کے لیے جا رہے ہیں, تو اگر آپ ہولڈ کرتے ہیں نا تو میں بریک کے بعد آپ سے بات کر سکتا ہوں. انشاءاللہ we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. As always, a popular way of getting in touch is to send us a message on the mobile number. We're a caller who I was speaking to just before the break. Let's see whether our caller is still there or not. Hello, Assalamu alaikum.
وعلیکم السلام.
جی بہن
میں
سوری
نے
ہے, بریک پہ ہم
اسٹوڈنٹ کے
چلے
بارے
گئے
میں
تھے.
پوچھنا تھا کہ
جی
اسٹوڈنٹ اگر آتا ہے ادھر, تو اس کا اگر وہ لڑکی ہے تو اس کے ساتھ اس کا ہسبینڈ آتا ہے اور ایک بچہ ہے, اگر تو اس کے لیے ان کو کتنی وہاں پہ بینک اسٹیٹمنٹ کتنی شو کرنی پڑتی ہے
جی
اگر وہ ماسٹر کرنے کے لیے یہاں آتے ہیں؟
جی جی تو اس میں ہے نا, اگر وہ ٹوگیدر آتے ہیں نا, تو رفلی ایک ون پرسن کے لیے جو مین اپلیکنٹ ہے نا, اس کے لیے رفلی اباؤٹ 12,000 پاؤنڈز بتانا پڑتا ہے سیونگز میں, اس کے لیے ون پرسن کے لیے. پھر جو اس کے ڈپینڈنٹس ہوتے ہیں نا, اس کا بھی ایک کیلکولیشن ہوتا ہے, مگر رفلی اس کے لیے مجھ کو ایگزیکٹ یاد نہیں ہے, اور رفلی اباؤٹ اس کے لیے بھی اباؤٹ 7-8,000 پاؤنڈز اور ایچ پرسن کے لیے بتانا پڑے گا. मुझको एग्जैक्ट कैलकुलेशन अभी याद नहीं है, मुझको चेक करना पड़ेगा, मगर उसकी एक कैलकुलेशन होती है. सो मेन के लिए अबाउट 12,000, नेक्स्ट वन के लिए अबाउट 7-8, नेक्स्ट वन के लिए अनदर 7-8,000 पाउंड्स. वो काफ़ी सेविंग्स बतानी पड़ती है, मगर वो सिर्फ वो शॉर्ट टाइम के लिए बताना पड़ता है.
ये
सो
लेकिन अगर जैसे आप कह रही हैं तो ये अबाउट मतलब 20,000 पाउंड तक के हो तो हो सकता है.
हो सकता है.
अगर
सिर्फ ये है ना कि वो शायद चाइल्ड का नहीं होगा ना. चाइल्ड के लिए समटाइम्स वो ज़्यादा चाहिए ना. सो उस पर होम ऑफिस की वेबसाइट पे वहाँ एक कैलकुलेशन होता है कि कितना होना चाहिए रफली अबाउट. वो भी देखते हैं कि लंदन में पढ़ रहे हैं या बाहर. सो डिपेंडेंट के लिए रफली अबाउट 7-8,000 पाउंड्स होता है. ईच डिपेंडेंट के लिए रफली 7 to 8,000 पाउंड्स होता है.
ठीक है.
सो अगर 2 डिपेंडेंट्स है ना, तो वहाँ रफली अबाउट 16,000 पाउंड्स तो वहाँ ही हो गया ना. फिर मेन
ठीक है.
एप्लीकेंट के जो पैसे होता है तो 20,000 से थोड़ा सा ज़्यादा हो जाएगा.
ठीक है.
सो मगर वो पैसे अगर पेरेंट्स के अकाउंट में है या तो जो आ रहे हैं उसके अकाउंट में शॉर्ट टाइम के लिए भी होता है ना, तब भी
हाँ
वो
जी.
वो वो हो जाता है. वो इतना इतना प्रॉब्लम नहीं होता है मेंटेनेंस का. वो फैमिली वाले
ठीक
भी
है.
उसको कुछ सपोर्ट करते हैं, पैसे बता देते हैं, तो फिर काम हो जाता है नॉर्मली.
ठीक है. ठीक है.
ठीक है.
ठीक है. तो उनको भी अगर अभी ये है कि अगर वो स्टूडेंट वीजे पे आते हैं तो 5 इयर्स वो रहते हैं इधर, तो उनको 2 साल के लिए वो वर्क परमिट देंगे, तो फिर उसके बाद उनको भी स्टे मिल सकता है इधर
जी,
इंडेफिनिट.
तो स्टूडेंट का सिस्टम थोड़ा सा डिफरेंट है. लेट्स से कोई स्टूडेंट पे आ गया यहाँ और उसने डिग्री कर ली, सो मास्टर्स फिनिश कर लिया, तो फिर उसको 2 साल काम करने की इजाज़त देते हैं. मास्टर्स करने के बाद 2 साल वो काम करते हैं कोई भी जगह पे. वो स्पॉन्सर की ज़रूरत नहीं होती है, वो कोई भी जगह पे वो काम कर सकते हैं. मगर इसमें प्रॉब्लम क्या है कि इससे वो इनडेफिनिट नहीं मिल सकता, इससे परमानेंट कभी भी नहीं मिल सकता. परमानेंट के लिए ये जो आपने पहले बात की ना, ये स्किल्ड वर्कर स्पॉन्सर वाली सिस्टम में जाना पड़ता है.
हम्म.
सो ये जो स्टूडेंट है मास्टर्स के बाद 2 साल की जो काम की इजाज़त है, इससे कभी परमानेंट कभी भी नहीं हो सकता. इससे निकल के ये स्पॉन्सर्ड वर्कर में जाना पड़ता है. ये स्किल्ड वर्कर जो है ना, वो काम वाला जो उसको स्पॉन्सर करता है, वो वीज़ा में जाना लाजमी है. और वो वीज़ा में 5 साल करने पड़ते हैं, तभी इंडेफिनिट हो सकता है.
तो अगर वो कोई अपना बिजनेस स्टार्ट कर लेते हैं इधर,
जी जी, वो पॉसिबल है, वो पॉसिबल है, मगर वो बिज़नेस है ना, थोड़ा सा बड़ा होना चाहिए ना. कि जो मास्टर्स के बाद जो उसको इजाज़त मिलती है काम करने के लिए, या तो जो हस्बैंड है वो स्टूडेंट है, वाइफ वो स्टूडेंट नहीं है, और वाइफ ने कोई बिज़नेस यहाँ शुरू कर लिया, तो बिज़नेस काफ़ी बड़ा हो गया. लेट्स से इसमें 5-6 बंदे अभी काम करते हैं, तो हो सकता है कि इसके अंडर में वो वर्क परमिट ले ले. हस्बैंड एज अ मैनेजर इसमें खुद के बिजनेस में वर्क परमिट अभी ले सकते हैं, तो वो भी पॉसिबल है. मगर बिजनेस थोड़ा सा स्मॉल बिजनेस में वो नहीं देंगे ना. वो बिजनेस थोड़ा सा बनाना पड़ेगा ना. सो फॉर एग्जांपल किसी ने कोई शॉप ले ली, शॉप पे 6-7 बंदे काम करते हैं, तो एज अ मैनेजर खुद के बिजनेस में एज अ मैनेजर वर्क परमिट मिल सकती है.
अच्छा.
ठीक है,
ठीक है. थैंक यू जी.
नो प्रॉब्लम है. चलो, जज़ाकल्लाह आपका कॉल के लिए.
जज़ाकल्लाह.
Thank you. Thank you very much. Jazakallah. Okay. Interesting question, because as far as the work permits are concerned, the advantage of the work permit skilled worker route now is that potentially you could be involved in setting up a business. And as long as the business is of sufficient size, that business could potentially qualify for a a sponsor license, which would mean that ultimately you could use your own business to sponsor you to live in the United Kingdom. That is possible. Now, it's quite easy to say. It does require a number of steps to achieve that goal. And what I would suggest is if you are looking at doing that, that you do get advice from an experienced immigration lawyer who will be able to tell you the various steps that you need to get through to get to the ultimate stage of the business getting a license and you being sponsored by that business to stay in the United Kingdom with your family. So it's absolutely possible, but it is a bit complicated and it can potentially be done. But Jazakallah, thank you very much for your call. Okay. Let's look at the next question that's coming. Again, a question on skilled worker visa, the work permit visa that we've had a couple of questions on today. And this relates to what the salary has to be for a skilled worker visa. Our viewer says, Assalamu alaikum, would you be able to explain what my employer would have to pay to sponsor me under the skilled worker route? Is there a minimum salary that has to be paid? Now, this is a slightly complicated area. The reason I say it's slightly complicated is there are minimum salaries which apply to skilled workers. But there are different ways in which the minimum salary is calculated. So if I give you an example, somebody who's over the age of 26 and not a student, they have a particular minimum salary of around 25,600. Somebody who's a new entrant, so under the age of 26, or somebody who's a student here qualifies as a new entrant, their salary is lower. Then you've got a situation where somebody might be filling a shortage occupation post. So they could be working in the UK as a healthcare assistant. Their salary is even lower. So you have differing minimum salary thresholds which apply to jobs. You also need to look at what the going rate for the job is. So if I give you an example where you are a doctor, then a doctor, if you look at that post, it will have its own minimum salary. So for that, you can't say, well, over the age of 26, you're going to pay them £25,600. Yes, that's the minimum salary, but it's not the minimum salary for that particular post. So you'd have to beat that as well. So although I understand your question, it's difficult to give a very simple, straightforward answer to that, because in answer to what is the minimum salary which is acceptable for a skilled worker visa, you do need to look at the post. You need to look at whether you qualify for a new entrant visa, a shortage occupation post visa, or whether you apply for just the normal adult rate, what's the going rate for the post, etc. So it is actually a bit more complicated than that. And that's why it's important, if you are going down this route, speak to an experienced lawyer who deals with sponsorship licenses and skilled worker visas, because it's too easy to get it wrong. Now, the problem is, if you get that wrong, what's likely to happen is that your skilled worker visa is likely to be refused, and that's going to cause problems for you. Now, at the moment, sponsorship licenses, skilled worker visas is something which is becoming quite popular. And if you look at the background, the reason why the Home Office has made this easier is following Brexit. There's a shortage in the number of people looking for work in the UK, problem with the labour force. And to alleviate that problem, the Home Office thought the way to do it would be to make it easier for businesses to sponsor skilled workers to work for you in the United Kingdom. So that's the background to it. To some extent, it is easy to qualify under the skilled worker route, but there are a number of traps there as well. So you need to be careful of that. From the moment you apply for a sponsor license, the supporting documents you need to submit for a sponsor license. If you get a visit, what happens at the visit, what kind of questions they ask, what kind of answers you should be providing, what you need to look out for. If you've got a license, which jobs qualify for a skilled worker visa, what is the salary which is acceptable, you know, numerous other similar issues. How do you operate the sponsor management system, SMS system? What do you need to report, etc.? So it is quite complicated. So if you are looking at that, if you are a business looking at a sponsor license, if you are a worker looking at obtaining a skilled worker visa, do get proper advice in relation to this, because there are various problem areas where you don't want to run into difficulties. Thank you very much for that. Now, interesting questions we've had in today relating to these areas. I think what we might do, because of the number of questions coming in on skilled worker visas, is look at that in greater detail in terms of how you as an employer go about getting a sponsor license, what you need to be doing, and I can talk you through what the issues are. So any questions around that, please continue to send your questions in, and I will address that in next week's show. Inshallah, we'll be back next week. Assalamu alaikum.